Appeal parted in the matter of Cérélia Group Holding SAS and another, and Competition and Market Authority.
Just before you resume, Mr. Palmer, can we just raise an issue? And this is not being critical at all. In the bundle, there's a chronology at tab 6 in the core bundle. Doesn't help us as to what was going on in terms of the investigation and the preliminary findings, and when submissions were put in, and when disclosure was given and documents were, as it were, landed on the CMA between June 22 and effectively November 22, when the 8-week extension was put in place. And it would be very helpful if we could have, as it were, an expanded chronology that dealt with those issues, because we think that might help us to put some flesh on the bones as to what was going on here and whether there were or were not special reasons.
Yes.
Okay. Yeah, I'm not asking you to do it now.
No, we can certainly provide that.
Team could look into that.
Well, I have one because my team did it for me overnight, so I'll share it with the CMA.
Oh, okay, well that would be helpful. Thank you very much. Yes, Mr. Palmer.
So I'm going to turn to the evidence now on bells, which was before the CMA.
Yeah.
And we bear in mind that in reviewing that evidence, the exercise that we're engaged on in assessing whether there was evidence of some probative value on the basis of which the CMA could rationally reach the conclusion it did. I start at page 288, behind tab 10 of the core bundle. That's the final report, internal page 123. It's table 9.1, which we've seen already.
Yeah.
I'll make two observations about that table. The first, the court will recall, if you'll note that the reference is paragraph 9.173, that until September 2022, Bells had two tiny private label contracts. You will see to what extent those contracts registered as a share of wholesale supply, easily by reference to the 2021 figure for Bells. And indeed 2022. So those are those very small contracts.
So they don't really amount to anything at all?
No. September 2022 is when they came to an end.
Were they? This table, I think, covers about 80% of supply to retailers as a whole. Is that right? Give or take. It's not all retailers. This is large grocery retailers.
The grocery retailers, yes.
Yes. So we have to bear in mind it's large customers, not small customers.
Yeah, but that includes the grocery retailers for whom they had those two contracts.
Yes.
Can I just show you, though, there's another, in the left-hand column, other branded, which you see is 7% all the way through those 3 years. And there's a little cross mark by other branded, which we can pick up just below the notes. Other branded includes brands like Bells. Based on a different data source, we understand that Bells branded products had approximately, and there's a figure which is within the range of 0 to 5% share of wholesale supply in 2021. So, as was explained to the tribunal below, the Bells figure you have is private label only. And of course, the private label are the supermarket owned brands. And you see that from the asterisk as well. There's a note there making clear that it wasn't a literal 0, but it doesn't register. So that's the context. They were nonetheless also supplying their branded products. So now we turn to the evidence which was before the CMA as to the constraint, and that starts at page 351, internal page 186, from paragraph 9.172. And the conclusions which you've seen. Now you'll recall Mr. Hoskins analysed the conclusions in under four headings. And the first point I wish to make, it's important to understand, although that might suit one's forensic purposes in going through the evidence, one must bear in mind that CMA takes an overall view of the evidence, does not analyse it in silos, and those categories of evidence have an interrelationship. And indeed, they have an interrelationship with other evidence, such as some of the evidence I went through yesterday, which I'll show you in due course as well. So it's an important point of context to bear in mind. Now, the first point that was made was by reference to the internal documents. And the conclusion on that, the court will recall, is at 9.192 in the first sentence, internal page 192. And there's 2 points made there. Of course, the court will understand that CMA did accept that bells was a constraint, just as a matter of degree. It was a limited constraint. So the 2 points there is that Cérélia perceives bells as a constraint, which was accepted, but although the evidence is mixed on the strength of that constraint.
Yeah.
And that is a fair conclusion based on what is set out in the preceding page 9.189 through to 9.191. And to answer Lord Justice Green's question of yesterday, yes, that does include 9.191, because what is at 9.191 is relevant to whether GMI perceived Bell's PL offering as a constraint at all. So by extension, if it is a constraint, it supports the view that the evidence is mixed on its strength. The underlying document, I won't go back to the underlying document that you saw yesterday by reference to 9.190. The court has the points that we wish to make on that already, which as the court observed, it strongly supports the fact that there's a mixed evidence, the strength of the constraint. Indeed, that might be generous. But can I just take you to one other document which features at 9189C, because you will recall that on Mr. Hoskins' presentation, all those points at 189 are on one side of the ledger, as he put it, and it's only counterweight by 190. But that is too simplistic a view, if I may respectfully say so. If we go into the rationality core bundle at tab 23, page 82,
Sorry, tab
23. The court will see just by the first hole punch, a third of the way down, the sentence which is extracted and included in that paragraph I've just shown you. And that is a response to a category manager emailing a group of people within Cérélia. And you will see that the exercise being done refers to the top 4 retailers. And you'll see the first bullet point that Bell's produce the following products, all of which are puff pastry. Those are all branded products. They're all branded. They're all, you can see that from the fact they're labelled Bell's. And this is June 2022, of course. And then the next bullet point, as to the extent. And then the final bullet point, as to where it is stocked, the data that they have, and the regional limitation. Again, relevant to the strength of the constraint when read in context. So all puff pastry, all branded, quite small and regional. Nonetheless, they're keeping an eye, as anyone would. And what they actually thought of them as a threat is revealed by that document we went to yesterday, which, if you'll note again, is at 9190, and it's at it's at tab 6 of the rationality core bundle, page 16. We don't need to go back to it. So that was the internal documents. We say that evidence of probative value is the strength of the constraint. Then we came to retailers' views. And again, the conclusion on that, 9.192, was that evidence from retailers, except two named ones which were there, suggests that Bells is not currently perceived as a strong alternative supplier. That came under attack, firstly by reference to paragraph 9.184 on internal page 189.
9.184.
Paragraph 9184. That's the first paragraph to come under attack. The first point to note about this is that the point being made by the CMA is that only 1 out of 9 customers that responded to the phase 1 questionnaire mentioned Bells. So one did, yes. The first point is, when asked in a questionnaire, who are the main suppliers of PL products, only 1 of the responding supermarkets identified Bells. And of course, from context, we know that is because Bells was at that time supplying that particular supermarket. The other supermarket it was supplying didn't return a questionnaire.
Sorry, I'm being really dim. I just can't find where you're...
Sorry, it's
Page 354.
right, internal page 189.
Internal page 189, sorry. Yep.
And then it was paragraph 9.184.
Sorry.
You may recall we were taken to this paragraph yesterday by
Yeah.
Mr.
Yeah,
Hoskins.
sorry.
And the point is only 1, and it's one of the 2 groceries who were being supplied by Bells at the
Identified
time.
as supplying when
Yeah.
they stopped
then it-
doing so.
That came to an end in September 2022, but you can see from the date of this was a response in February 2022. The other supermarket which was being supplied by them didn't return a questionnaire, so that's why they didn't mention them, but of those who did, these were the only ones. Again, that's of some significance.
Yeah.
But in that context, it's then relevant that then stopped, as they're observed in the following sentence, because the quantities, as you saw yesterday for the underlying documents, were tiny. And you have more details of that in the rationality core bundle.
Sorry, just following the point about 9184. The point you're making is this, that of the 9 who responded, only 1 said that Bells was actually a main supplier.
Yeah.
The others didn't mention Bells.
Didn't mention Bells at all.
Okay.
So, I mean, it's a limited point. I'm not saying, but that's the point being
No,
made,
no,
and
I
it has a
understand,
rational
I
basis. That's all. You know,
understand.
I'm not saying that everything can turn on that,
Yeah.
but there is a rational evidential basis
Yeah.
for that observation. Is all I need
No, fine.
for the purpose of this point. And then at tab 35 of the rationality core bundle, page 185. That's a note of a call with that supermarket. And I just ask you to read paragraph 2. Here, as ever, throughout, as you know, that call would have picked up, Goldenacre is Hengline. And that is Hengline's presence in the UK is called Goldenacre. But if you could just read that paragraph. We simply say all this goes to the weight to be attached to any suggestion that Bells was a significant constraint.
Yeah.
Its limited small-scale involvement now ceased. Telecom, of course, we come to their big new contract beginning January 2023. We move on to that.
Yeah.
So I move on to that point and that retailer. So following the award of that contract, we know that Bell's share of supply was projected to increase to a figure between 5 and 10% from January 2023. Again, that's from table 9.1 in the text. But let's just look at the...
Can I just ask you, is presumably the fact that Bell's is a supplier to this retailer is in the public domain, and its products are in that retailer?
It's not, no. It's I understand it's not. Of course, its branded products will be maybe in that retailer and other retailers, and that's in the public domain. But who is the manufacturer for supermarket own label brands is often kept confidential. Often the supermarkets don't want it to be known who it is, or whether it's the same person that is also manufacturing the branded version or not, as the case may be.
If it's only so it's only really the third sentence of paragraph 2 that's confidential, isn't it? That's to do with the private label position of that supermarket, that retailer.
Well, the first sentence would be we're not concerned with that, but
Oh yeah, sorry, the first sentence and the third sentence.
yes,
And the stuff about the branded.
no, not branded. No, and you can see that from walking into a Scottish supermarket and seeing it on the shelf.
If I went in, presumably, if I went into one of these, one of their shops in relevant part of Scotland, I'd find Bell's branded.
You'll find Bell's products in pastry in Scotland. Yeah, pastry and pies more. All right, so I want to turn to the evidence on that supermarket which awarded that puff pastry contract. I want to show you what that supermarket itself said about Bell's within that context. Firstly, before they decided on the award of that contract, then during the time when they were considering and granting it, and lastly, after. And of course, these are internal documents to that supermarket and not documents to which Bell's would have had access or would have seen. I'm going to ask you, without elaborating further, to bear that in mind when you come to view what Bell's said about this contract and the potential for growth.
Yeah.
So before is at Rationality Core Bundle tab 11. Page 31. See that those are minutes of a discussion with the supermarket dated March 2022, so that's at the phase 1 stage. And if I could take you to paragraph 6 over the page. Just ask you to read that. That's not marked as confidential, so they're saying at that point that Bell's provides an escape avenue. However, its capacity is extremely limited, and the supermarket understands that they're not looking to expand capacity at this point. And then paragraph 17 on page 34. This is in the context of how it might, of its views on the transaction. It expresses its concerns at 15 to 16, which I need to take time over. The court will see them. That's the context. Then at 17, it identifies a counter strategy. Could be the supermarket could always move the business to Hengline, but as previously discussed, there are clear obstacles to doing this. Another counter strategy would be to move business to Bell's, but their capacity is limited, such that Bell's would only become a relevant option for part of the volumes only. And the next sentence I'll leave to read, and the last sentence as to why that's not an attractive course for them. So that's what they were saying as at March. You can see they're contemplating the possibility of part of the volumes only. Then during is at tab 25, page 124. Which is minutes of a discussion with the supermarket in June 2022. So we're now into phase 2. Paragraph 3, you see what is recorded about the supermarket's process. Specifically, it was looking to move a proportion of its volume away from Cérélia.
Yeah.
It says why. And then over the page at 4,
What's KPI?
key performance indicator. Paragraph 4, however, there's little capacity for it to move business based on the current makeup of suppliers. The reasons of this are twofold. Firstly, limited capacity in the UK marketplace, and secondly, it didn't consider continental supply routes where alcohol is used as a preservative.
That's why they put alcohol in the pastry.
Yeah. Hengein,
I did wonder about
Hengein's recipe has alcohol in it, and
Ethanol.
ethanol.
ethanol, yes, exactly. They refer to it as alcohol, but it is, I think, ethanol. Yeah, it's not. Yeah, it's not a slug of whiskey. It's but as you will see on the evidence on the Hengein, many of the supermarkets don't like that, and for that reason don't want it. So they may be looking to shift some volume to existing capabilities and infrastructure by looking at existing shift patterns to maximise output. But so that's what they say there. And then at 16 to 17, under the heading Supplier Options, you can see that they have recently awarded business on the basis of its review. And this will involve an expansion of existing capacity as the relevant supplier is reviewing its shift patterns to maximise volume out of its facility. 17, the award of longer-term contracts is another tool that they can use to drive capacity investment. They're not looking at that, as you can see, just by scanning down, particularly the last 6 to 7 lines of that paragraph. They've not considered the award of contract lengths due to commitments. These are generally awarded only when there's a strong relationship in place. High degree of internal governance awarding to ensure the right decisions are made, and the final sentence. And then finally at 19 over the page, under the heading Views on the Merger, this is lavender, so I can read it as long as I don't mention the supermarket. The merger will leave that supermarket with one supplier in the DTP product category capable of supplying a full range of products. So that is the merged entity, in other words. That could affect its ability to negotiate. So even though it is moving its puff pastry volumes to another supplier, it is concerned that the merger will only leave it with one supplier in that product category capable of supplying a full range of products. And then after, we can go to tab 30, page 150. This is a phase 2 questionnaire, and it's dated 21st of July 2022. And you will see question 14, which appears on page 153. And the second paragraph of the answer just records, as a result of the supply-based review on the own label pastry, and after careful consideration, we've decided to award our puff pastry business to Bells, and the orders will commence in January 2023. And then question 15, what options are available to you if you're not happy with aspects of your current PL product supplier's offering? And they say, we've had meetings, these discussions can be challenging, and if not successful, a particular course, which of course is relevant to the flexing process, but that would be as a last resort. Finally, a supply review process may be launched to consider other options. However, as indicated previously, they're still making that point. Alternative options are very limited. And then question 17, what's the impact of the merger would have on your negotiations with your PL and branded product suppliers is the question. And the answer is, as we indicated in our call back in March, we believe our ability to negotiate may be hampered on both own label and branded. whilst we decided to move our own label puff pastry business to Bell's, we were unable to move our short crust business. Our view is that Bell's does not currently have the capacity to also absorb short crust volumes, and there's no other alternative supplier in the UK and in Europe that could serve this part of the OL business. A reason why the Hengein recipe was not suitable, and this is why, whilst we can't predict what would happen, we are concerned our bargaining position would worsen. And over the page at question 18, if you were to switch to an alternative supplier of private labels, who would you switch to? And some observations first about Hengein and then about Bell's, who they describe as a puff pastry specialist, is able to produce in line with Tesco, in line with guidelines. However, factory capacity and ability to expand is a concern. Yeah, 22 on the question about how easy or difficult is it to switch. They again say that there are challenges, it's difficult. And again, they make the point in the final sentence, Bell's are unable to service the entirety of our own label dough to bake demand. And as we'll see later from some of the Bell's documents, this is after, of course, as you would expect, the supermarket had done a full audit of Bell's production capacity before awarding the contract they did award. So they're well aware of its capacity, and this is their view. So it's on that basis, if you turn back to the decision now, the final report in the core bundle.
You told me the date of this document at the beginning. Is
That
it
was
June?
July 22,
July 22.
specifically 21st of July. So you'll see the observations back in the final report, internal page 187, bundle 352, paragraph 9177. Which refers to the supermarket's recent review, the award of the puff pastry business, and on this basis, the revised forecast in 2023. But in relation to this, the supermarket told us that it didn't believe, well, this was confidential at the time of the report, but as you've seen from the markings of the documents I've just gone to, no longer so, it didn't believe Bell's would have the capacity to supply the entirety of their volumes. It's not committed to a duration for using them as a supplier, but they were able to offer a better quality product, which was in line with their guidelines. But of course, you recall that specifically referring to the puff pastry product. And secondly, over the page at paragraph 9185, you'll see there that now we're onto the phase 2 questionnaires. Again, only one, that's this supermarket now, but only one out of 7 customers that responded to our phase 2 questionnaire submitted that if it was to switch PL supplier, it would switch to Bell's, and that retailer commented that they're a puff pastry specialist and is able to produce in line with their guidelines, but that factory capacity and ability to expand is a concern. Conclusions and observations which are amply justified by the underlying evidence. And so you then come to the next retailer to which my friend referred, which is that referred in the following paragraph, 9.186, first sentence. One retailer told us it's probably had some limited interactions with Bell's, but from its understanding, you see that what follows there, you'll recall that came under some attack, saying being outdated by Mr. Hoskins. But actually what is said there, based on this supermarket's own understanding, is exactly the same as what the first supermarket had said. You recall the final paragraph of the final note that I showed you, the distinction between being a puff pastry specialist and being able to offer full offer. Now, again, that is the significance of that point. And that point was important to this retailer. Some retailers might be happy to have more than one contract. Some retailers might be happy or might prefer to have a single provider. And their observation was based on what was available from a full offer. Let me show you briefly 3 documents from that retailer. It's Rationality Core Bundle, tab 12. Page 35. You'll see it's minutes of discussion with this supermarket of the 15th of March 2022, so again at the phase 1 stage. Paragraph 3. This supermarket only uses bowls in Scotland for a regional set of SKUs, puff pastry only, SKUs, stock keeping units or individual products in other words. Puff pastry only across 12 stores. You recall that had its reflection in a Cérélia internal document that we saw earlier. An observation about bowls and the reason for that choice, i.e. why they stock those 12 stores, is given. In the 12 stores where Bell's products are sold, there may be examples where both sets of products are available, that is private label and branded. But despite paragraph 4, this ongoing relationship, and then there is that concern which is picked up in the final report. Whilst on this document, can I show you paragraph 19 on the next page? Similar attitude towards that possibility, as it happens, the other supermarket had expressed. Then at tab 32,
CapEx in this context is capacity expansion.
capital expenditure.
Capital expenditure in capacity.
Oh, yes.
But capital expenditure, yes, of course.
So where are you next going?
Tab 32, page 166, is the phase 2 questionnaire from this event. This is the 25th of July, 2022. I just want to show you one answer, which is on page 169, in answer to question 15 again. What options are available if you're not happy with your current PL product supplier's offering? I'll answer in the first line, again with the emphasis on all of its needs. Now, this is a supermarket we know that knows Bell's and does have interactions with Bell's. But they mention only Henglein next, and various reasons why they're concerned about them. And then lastly, at tab 50, page 249, is an extract from a call with that supermarket in November 2022. And at page 251, there's a question and answer starting at line 3, running through to 11. I ask you to read lines 3 to 11, page 251. And again, the emphasis is the same as it has been consistently. What they're concerned about is not can they take puff pastry. And this hasn't changed. There was no need to go back to them with the information about the first supermarket's puff pastry contract, as Mr. Hoskins suggested, because nothing had changed in that respect. And in any event, it's entirely inappropriate to start taking information supplied to the regulator by one competitor and give it to their competitor between these two supermarkets. This is information obtained during the course of the investigation that's subject to Part 9 of the Enterprise Act. There's strict rules as to disclosure of this information. The idea that you'd say, oh, very interesting, but your competitors just entered into this contract with Bell's for this product. What do you say about that is entirely inappropriate in any event. If evidence is, of course, overtaken by events in that way, which, as I say here, it had not been, but if it had, that's a matter for the CMA to consider when it's deciding what weight to attach to those earlier answers. It's not for a matter which has to be put back with a sort of follow-up consultation with that other. But again, it goes to weight, it goes to reasonableness. Again, here,
Well, the concern is a capacity concern, isn't it?
Not just capacity, but
not just
capability.
capacity, but one of the main concerns is capacity with Bell's.
Yeah.
If Bell's had, as it were, built a new factory,
Yeah.
then the CMA would have to.
Possibility is considered later on down the line.
All it's talked about is the possibility of their restructuring.
Yeah.
What they manufactured in their factories.
Yes.
But they themselves were saying they didn't particularly want to switch to manufacturing puff pastry, manufacturing dough to bake pastry.
Dough to bake or
They
pizza.
like manufacturing pies.
I'm going to show you the evidence on that a bit later on as well.
Yeah.
But their concern is dual, it's capacity and capability. So you'll remember all the evidence, the argument being strongly put by the merging parties to the CMA during the investigation was, well, look, notionally, they've got all this capacity big enough to take another major supermarket's requirements. But what they are in fact saying is they don't have that capability to do this. Both the supermarket which has entered into a puff pastry contract with them is saying that, and one which wants a full offer is saying that. The next retailer is also mentioned in the same paragraph we are on, that back in the final report 9186, which told the CMA, we see there in the second sentence, that it had previously considered Bell's as part of an exercise to consider the competitiveness of its current offering. And we went to that document during Ms. Hoskins' submissions, and you may recall that it was just an early dismissal of Bell's as an option, which wasn't taken further. Let me take you to two other documents from that.
Just remind me, have you got a reference for that so I don't have to cross-refer for that earlier document?
Yes, I do.
Is that in the rationality part?
It is, in fact, I'll take you back to it to show you one other aspect of it. So I'll take you to that document. But the reference is Rationality Core Bundle, tab 48, page 241.
Yeah.
That's what Mr. Hoskins took you to. I'm just going to take you something else there as well. But first, can I just take you to tab 39?
39.
Which is the supermarket's phase 2 questionnaire. This is the 4th of August 2022.
Yeah.
And can I take you to questions 18 and 19, which page 201. Question 18 on 201 was, if you were to switch to an alternative supplier of private label products, who would you switch to? And you can see the answer. And question 19 is the same question in respect to branded products.
Branded, yeah.
And you see the answer which is given there. And that is August 2022. Then in November 2022, 25th of November, it's tab 48. That's the call. You were shown yesterday, page 242, lines 7 to 15, saying they decided not to further those conversations. There's an explanation as to why at page 243, at lines 11 to 14, the answer is not to the standard that we require and the cost that we are looking to achieve. That refers back, if you go back to what's at line 11 on the previous page, against the same concerns. that includes the standard that's required by that supermarket. So again, 3 major retailers, none of which look in the foreseeable future to award a contract to Bowles. The next is another major one. Can we go to Rationality Core Bundle tab 45? This is a hearing 26th of September 2022, and you'll see the identity of the supermarket on the heading on that page. And on page 219, to 220, you can see that conversation. I won't read it out. But again, at the bottom of the page, 219, on own label in the UK, again, we're quite limited on own label suppliers. From what we can see, there is Bell's, I've mentioned, who do in Scotland. Otherwise, we probably source more from Europe. At the moment, probably we have limited choices. In the UK, this sort of volume would require on own label. And explaining the relative importance of 2 levers goes on to explaining the flex, because at the end of the day the products are very similar. Then at page 222, lines 18 to 21. And 223, line 24.
Just on, I mean, maybe I understand this, but there's a reference there to, at lines 18 and 19, to 2 problems.
Yes.
It's the second one. Is that sort of alcohol related? Something
No,
else?
it's a quality concern because UK suppliers don't use ethanol.
So it's
So
just,
it's a feature of continental dough.
so it's just a quality.
Yeah, it's a quality issue. Yeah, 223, line 24, again, they say something about Bell's there. You see how they limit their observation on that. And then at tab 47, there's a discussion with the same supermarket in November 2022. The specific context of this discussion was about remedies. So this was all proceeding at the same time on the footing if there were a finding of SLC, what would be the appropriate remedy. I just want to show you paragraph 6. This was in the context of a discussion of a remedy which the merging parties had proposed, which was to dispose of a production line, to sell a production line, sell the equipment. And paragraph 6, they make some observations on that, including their about Bell's confidence in their ability to deal with a huge contract. That again has some echo in what Bell's say themselves about their appetite for another contract the size of the one that they won. So that's 4 supermarkets who don't show enthusiasm and clearly aware of Bell's, and in the first, of course, have been audited their factory. But going back to the decision at 9.186, 9.187 now,
Yeah.
is the other retailer, which was a recognised exception to the observation, which appears at 9.192. And just the substance of what they say is properly gisted there, so you can read it. But I want to make a further observation about that, which is at tab 51 of the Rationality Core Bundle. I just want to show you paragraph 1.
Sorry, give me the reference.
So it's Rationality Core Bundle, tab 51, page 252.
Yeah.
Paragraph 1. They stock a puff pastry product and a short crust pastry product and a pizza dough product. The current supplier of the DTB, that's the those products, is, then you see who it is. Well, that's of some significance because you'll recall that much of the conjectural exercise that was being considered about, well, what if Bell's won another big contract? Mr. Hoskins proceeded on the basis, well, that would be from Cérélia. Well, in the case of this supermarket, who was an early stage of its exercise, that cannot be assumed. For your note, I won't go through it, but the substance which then appears in the final report is at paragraphs 5, 8, 10 and 12. There's no need to spend time on it now, but that is the source of the observations which make their way into the final report.
This is relatively small compared to the previous ones we've been looking at.
It is, yes.
It's paragraph 2.
So it's all together rather unclear, if I may say so. We can get to the even if point in a moment, but if one turns back to the table I showed you at page, in the core bundle, page 213, internal page 48.
Yeah.
I've shown you 5, the top 5, what they said about their willingness to award a contract to Bell's. The next one has 0% in PL because they don't do PL. There's 2 others. We know Lidl and Co-op used to have the contract but ceased because it was tiny. And what's left is tiny and it's not applicable. So I think the data is just too small. So there is a reality here which needs to be assessed in terms of considering the potential constraint that Bell's will provide on a future merged entity within this context. And that is the evidential basis which underlies the observation which you have. So you have all that evidence set out, but the observation is at core bundle page 357, paragraph, it's internal 192 again, paragraph 9, 1 to 92, where it said, bearing in mind that much of this at this stage was confidential and it's not just as openly, but the headline conclusion is evidence from retailers, SEP 2, suggests that Bell's is not currently perceived as a strong alternative supplier.
Well, it might be thought to be generous in respect to the second.
Yes.
Actually.
In fact, yes, very early stage, but that caveat is there, taking into account
Caveat,
so
obviously,
the
'cause
caveat
they
is there as well.
Tendering, but
Yeah.
there's nothing much to suggest that they thought the Bells were
Yeah.
a strong supplier.
But this is a sentence which was criticised by a learned friend as having no evidential basis and inaccurate and unsupported. Quite the reverse. And of course, all I need to show you is a rational conclusion based on probative evidence. Now, all this of course, was done in response to submissions which were being made by the parties in their merger notice, which was from the 29th of March 2022. It's just worth seeing those submissions in the context now in which all this appears. Internal page 186, paragraph 9.175. So this is, if you like, the submissions made at the outset of the process, before most of this evidence had been gathered by the parties. I just want you to observe the extent to which these submissions were actually borne out or otherwise by the CMA's investigation. A made a submission as to capability, as to which you have my submission. B isn't borne out by the evidence gathered. Over the page, C, again, isn't borne out. And D, which is now the capacity point we come on to, market share and so forth, share supply, they were saying that based on what Bell's said of their capacity and based on the size of the puff pastry contract they had entered into, shows they did have unused capacity of a certain size, big enough, and then there's various permutations of what it was big enough to do, being advanced. But of course, that said nothing about capability, just pure capacity. So again, evidence next from Bell's, let's consider their position on this to show you two documents in the Rationality Core bundle. First is at tab 38. It's page 194. You see in paragraph 1, they describe their main products as ready rolled puff pastry and puff pastry blocks. 90% of their customers are supermarkets. They don't manufacture the dough to bake products, or the ready to bake products, I think they're called, referred to as, that's the pain au chocolat, croissant, cinnamon swirls, etc. Their dough to bake products are important and profitable. They also sell to other manufacturers. And in paragraph 2, small amount, there you see what the amount of those revenue from those two contracts was. It is, as I've observed earlier, tiny. They've given notice to stop manufacturing as volumes requested were so low. I'd like to focus on more profitable lines. That doesn't, of course, mean more PL manufacturing. It's a reference to all their business. You see their total turnover last year, mostly generated from pies. Packet pastry for retail generated that figure, and PL sales, that figure, and that percentage of turnover. And typically they're interested in larger contracts, the kind you see there. And then they go on to discuss their capacity. And paragraph 7, they just compare themselves with Cérélia. And they say they compete in Scotland. There's a much smaller market player, particularly in the PL market, which is dominated by Cérélia in Scotland. Further observations about the impact of their new contract. That's what they say about themselves, measuring themselves up against the big boy, if you like. And
that's perfectly. I mean, that might be thought to be an objective assessment of their own position in the market.
That's how they
It's
saw
not trying
themselves.
to talk themselves up. It's making a perfectly valid point that they weren't really known in England. Full
Yes.
stop.
Yes.
They were a Scottish company, and they're supplied in Scotland.
That's what they are. Family-owned business. They're not doing very well, but that's what they are. Tab 36. is Bell's response to the phase 2 questionnaire. So this is 29th of July 2022. And you'll see on page 188 that at this point, in advance of their new contract, although their new contract's been entered into, it hasn't started operating yet. So no PL products being offered. Question 2. Question 3, would you be able to adapt your manufacturing process to any of the products listed above? That's the full range. If you see in the purple text on the previous page, it's divided into chilled and frozen, and then the short crust, puff, phyllo, pizza dough, and ready-to-bake dough products. That's the croissant and so forth. And they say yes as to puff pastry and short crust pastry, both chilled and frozen. They already manufacture under their brand retail puff pastry, both ready rolled and block. We sell predominantly chilled pastry. We have the ability to manufacture short crust pastry, they say. But why haven't they adapted their manufacturing process in the last box? Phyllo pastry is more specialist to manufacture, investment would be required, investment risk would be high. We're predominantly a Scottish supplier as opposed to national UK. Pizza dough, ready-to-bake products require specific packaging equipment which we do not have, plus the cost of the equipment would be significant. Now, the results of all this, you'll recall that many of these documents dated from November
There's a bit of
2022.
inconsistency, but if you look at their answer to 17 over the page, which for some reason they seem to put in block capitals.
Yes.
Which
I mean, they do have
seems to me
that,
at least to be rather inconsistent with what they'd answered to question 3.
no, I don't think so, to be fair to them. They're saying pastry is important, they have excess capacity, so they have the more capacity in which they could produce puff with no difficulty at all. They say they have the
Oh,
ability
and they say the ability to manufacture short
short
crust.
crust,
Okay.
but they don't have the
Yeah.
ability to do other forms of
Yeah, okay.
products at the moment. So they have capacity, but that's not the same as capability. Now, much of this was gathered in November 2022, this evidence, which is why at tab 52, page 255,
It's just quite curious though, because in 3, in the box, you are predominantly Scottish supplier as opposed to national UK.
yes.
It's sort of slightly unclear whether they have aspirations, as it were, south of the border.
Sorry, I didn't hear you.
It's slightly unclear whether they have aspirations to expand south of the border.
Yeah, I think they're, again, reading their evidence fairly, they're excited by their new big contract, which will be their first substantial foray south of the border.
Which is a contract national.
That is a national contract.
Okay,
It's
yeah.
the whole of that supermarket's puff pastry, as I understand it.
Yeah.
But only that.
It's just curious that it's in answer to a question. Why haven't you? Would you be able to adapt your manufacturing process to produce these products? Yes. Why haven't you done so far? Because we're Scottish.
But also the investment required
Yeah. Okay.
in other equipment and so forth.
So maybe perhaps it's just that this has caught them at a point of
Yeah, this is
about to
they've
take
just
a big-
entered
about
into that
to
big.
take a
They've
big,
just
big
only
step.
just entered into that big contract. It's they've yet to have real life experience of delivering it.
Yep.
So I was just going to go to tab 52, page 255, which is the consultation on the additional evidence, which, as Mr. Hoskins said, was sent out on the 19th of December 2022. And the obvious point of this was to take account of various evidence which have been gathered on an ongoing basis, which has emerged since the PS in November. And you have, in particular, their consultation at paragraph 18 on page 256. Sorry, is that the right reference? 255, 256. No, sorry, that's an old reference. Paragraph 18 is now on page 258.3. It's internal page 7.
We've got a new. We've got the whole of the.
I think the original extract has been replaced with a fuller version. We've got the whole consultation now. I think initially, in an effort to cut down bundle size, an extract has been provided, but
So what we had in there originally can come out.
yeah, it can come out and be discarded. Yeah, this is a replacement. So it's 258.3, and all I want to show you, I would be repeating myself to go through it, is that at paragraph 18, what had been said by that manufacturer is all fully gested and set out to allow the parties to comment on it. 19, the same with the other. And then 20, some conclusions, provisional conclusions, which are being consulted upon. And that was all put out there for the parties to consider. And their response is at tab 53.
Again, we've got a replacement.
You've got a replacement now. Again, I'm not going to go through the detail of that, but you see some extensive submissions being made. In particular, at the bottom of page 264.2, it's not exhaustive. They go through evidence from various sources, but at the bottom 264.2 from paragraph 3.2, they argue, well, this confirms that Bells has capacity. And that is all what is considered in the final report. So again, the short point simply is that there was plenty of evidence form the view that they weren't perceived as a strong alternative supplier, and indeed the CMA had a good understanding of their appetite for and ability to provide, and retailers' willingness to offer a further major contract, whatever their theoretical factory capacity might have
There's
been.
a sort of sense of reading that of talking up Bells as a competitor.
Yes, in there, that's in their interest to say they're very
To
effective
objective
constraint
evidence.
on us. Very, very strong constraint, they say. That
Either from the retailers, bar the one with whom they've got a new contract, or from Bells themselves. And if you read the summary of what is said in the consultation about Bells, they don't seem to be over enthusiastic at expanding their capacity.
So again, just to get ahead of ourselves, this is all support for the ultimate conclusion that the constraint that they offer is a constraint, but it is a limited constraint, and then it's a matter of assessment as to whether that's strong enough in the overall context to mean that there won't be any competition concerns arising from the merger. Market share. I'm going to deal with Mr. Hoskin's additional point at the end. We're going to deal with the original point first. Again, that is in the final report at 9.193, that's internal page 192. Court is now familiar with these paragraphs, 9.193, 194, and 195. And it is on an even if basis because the parties' submissions were very strongly on, look, they've got this capacity and this capacity is big enough to take another contract of equivalent size to the one that's been awarded. But an important point on capacity are the various caveats which were inserted in those paragraphs. 9.193, these caveats skated over entirely by Mr. Hoskins, in fact. In the final sentence, beginning at which point, and despite. And then in 9194, even though this is again on an even base, this is assuming in the parties' favour, because this is the basis of their submission, that any contract won by Bells would be at the expense of the parties, rather than another provider, such as Hengai, in other words, it still remained less than 1/4. So again, that's two generous assumptions being made, not just one, which would hold a share. Of course, if it was one from Hengein, then their share would still be in the 60-70 range. But at which point, again, the caveats, their position would be Bell's, you can see in the first shaded bit, whereas the parties, and you see that point. And again, that is very relevant to the strength of the constraint that Bell's would provide on a continuing basis were this somewhat unlikely set of circumstances to occur.
Yeah.
And again, we'll come back to that, some findings in the report, which I'll take to you in a bit. So the market position, the conclusion is at 195, would remain modest, and it would be significantly smaller than the merged entity. And then we note in addition that the majority of grocery retailers do not consider Bell's to be a credible alternative supplier to the parties. Again, that's a slightly different point from the one above, the fact they're not currently perceived as a strong alternative supplier. But again, it is picking up on whether they have not just the capacity, but the ability, the capability, and the appetite to fulfill their needs. So on this basis, we consider that Bell's provides a limited constraint. Now, before I come to the additional market definition point, let's just finish off this section. This is the possibility of ability to expand in the longer term. You can see the conclusion there, but that is then considered in more detail in Chapter 10. And the reason that's considered in more detail in Chapter 10 is because Chapter 10, which begins at page 257 internal, 422 on the bundle.
Yeah.
This is the chapter dealing with countervailing factors. Now, at this point in the analysis, as you can see from the preceding paragraph, which is the conclusion on the competitive assessment, 9413, they've concluded that subject to our findings on countervailing factors, the merger has resulted in an SLC. So at this point, countervailing factors are not factors which go to whether an SLC would arise comparing the existing situation and the counterfactual, i.e. the position with the merger and without the merger. But it proceeds on the assumption that, okay, if the merger is to go ahead, how is the rest of the market then likely to respond? Might, in consequence of the merger, other parties start acting differently? If so, that would be a countervailing factor to the ultimate conclusion of an SLC. And one of the two main headings of things which could present a new constraint as a countervailing factor is entry and expansion, which you can see begins from 10.2 onwards. But at 10.5, and this is reciting from their merger assessment guidelines again, you see the context of this. The CMA considers that entry and or expansion preventing an SLC from arising would be rare. The CMA's evaluation of the selection of some of its past cases has shown that in some instances, when it has relied on entry or expansion to clear mergers, entry or expansion did not in fact materialise. The CMA will therefore seek to ensure that the evidence is robust when presented with claims of entry or expansion being timely, likely, and sufficient to prevent an SLC from arising. Now, there was no challenge to the conclusions in this chapter below or now. I'm just going to give you a list of, there are set out in my skeleton argument, but for convenience, you will find specific consideration of the possibility of Bell's future expansion. Paragraphs 10 point, 47, 51, 69C, 129, 137, 179 to 180, 190, and 197. So the possibility is fully considered. There's been no attack on those conclusions. And there's a conclusion at 10.200, 10.198, at page internal 301, bundle 466. You can see the conclusion on entry and expansion.
Sorry, but page?
Bundle page 466, internal 301.
Yeah.
And so there's 3 paragraphs. You see that overall conclusion. That's having surveyed the whole market and potential for entry and expansion from many avenues. But that's their overall conclusion, which leads on to their conclusion, internal page 305 on SLC 11.1. That's how they arrive at that conclusion. So, turning back to where we were on the analysis specifically of bells.
In reality, it is only the possibility of third-party competitive effects which could neutralise the SLC which is filed. So there's no entry or expansion by third parties from abroad. There's no sufficient retailer countervailing buyer power.
Yeah.
So the heavy lifting is done by Bells and Henkelin or nobody.
Yeah, or nobody. That's effective. Exactly. That's where we
So
land.
you're balancing that against the qualitative assessment of the loss of competition by the merger. But that's your balancing exercise.
That's your balancing exercise. What constraint do they provide? Is it enough?
And it's an important point that they make in this section, and they've made it elsewhere, that so far as Bells are concerned, the new contract with the main supermarket did not involve an increase in their capacity.
No, it's use of
It
existing.
didn't involve building a new factory or building new production lines or anything of that kind.
No.
Because if they'd done that, then it'd be much easier to say, well, they've done it once. Therefore, if it's successful, there's a real chance they're going to build more production lines to start supplying other...
Probably the CMA would interrogate their business case for that more closely.
Precisely.
But of course, it will
Precisely.
take you down that line of inquiry, yes.
But this is not, that's not this case. All they've done is to switch
Yes.
some of what they were doing.
And they had mentioned various potentials subject to shareholders' views
Yeah, sure.
and all the rest of it.
I've got
That they
that
might
in
do
mind.
this, they might do that, but none of it passed that test
No, none of it's got to the stage where they've actually
that I showed you in
started
10.6.
building, as it were.
But
Yeah.
just to be clear, the way it's set out in 10.47, 10.47, Bells has got its new contract with the named supermarket.
Yes.
It can take on an additional contract equivalent to that same capacity.
Yes.
Although in fact, I think it had actually said it would prefer something a little smaller.
Something smaller.
Exactly.
And it's only if it was to take on a further contract
Yes.
that it would require to do all the other things that.
That's right. And that in fact, that paragraph that you are referring to is effectively repeating in substance what you have in the Bells section. It's the same point, but being
The same point about
deployed in a
shareholders.
slightly different context
So,
to frame that evidence. So
but in fact, what it, I mean, the comments, the shaded comments, relate to the third contract.
yes, in effect there.
But it could take on more immediately a second contract, albeit that I think it said it would have to do some rejigging work at weekends and stuff. And
That takes you back
prefer
to...
to take on something slightly less.
That's right, Noel. And that takes you back to your reference to internal page 189. You've got the 2 paragraphs, 9.182 and 9.183. And 9.183 is substantially the same as the paragraph you've just referred to.
I'm not sure that extra
But
that you've referred to.
182.
I'm not sure it actually takes it
No.
any, although it says
No,
more
it's the
detail
same.
is given.
Yeah,
I'm not sure it is any more detail.
No, I don't think it is. I've given you a list of... Yes, that paragraph is not enough on its own. That's why I've given you the full list. But you're right to say that there's not more detail in that paragraph.
One of the points that I didn't quite follow, when they, because they cross-refer to 9183, where the same issue is debated, talking about the possibility of their taking on another supermarket contract.
Yeah.
Although it says they would prefer a smaller one.
Yes.
But what they then, and they say without the need to invest in any new capacity, but when they go on to say they'd either have to build an extension or or divest capacity away from their existing manufacturer. That's in relation to that second contract,
Third.
or into a third contract.
That's
Anything beyond the second contract.
That's the very point that was clarified during the course of the additional
That's why I asked
consultation.
the question.
One of the things that was still being investigated at the time when Colin and I should have been supporting producing our final report within the original timetable. But one of the things that should have been done, you see reflected in the conclusions from 9.196 to 8. That's the bottom of internal 192. Because initially, the CMA had understood that Bells would need to switch production from food manufacturing. Further clarity was brought about that, i.e. using additional existing spare capacity, and that is accepted at 9.197.
Yeah.
It wouldn't need to do
So
that.
they had to switch.
And then 198 is the overall conclusion. Still, it stands. Bells would exercise limited competitive pressure on the merging parties over the next 1 to 2 years. That remains unchanged in relation to how Bells might be able to meet what is said. And the other evidence that we took into account in assessing the strength of Bells as a competitor, including the uncertainty around its appetite for further expansion into the retail DTP segment, its limited overall market position, and even if it was successful in winning an additional large retailer traffic, particularly in comparison to the merged entity, and its perception with customers remains unchanged. That perception, of course, being their not just capacity but capability to manufacture not just types of products but also to the required quality that individual supermarkets might have. So all of that is being considered compendiously to reach the conclusion that no, there's still going to be a limited constraint. And the question for the court is, was there a sufficient evidential base of sufficient probative value on which rationally to arrive at that conclusion? And my submission, the answer to that is unambiguously yes. So I come then to the new point on market share. And the point raised is that the merged parties' market shares, as I recorded the submission yesterday, are not evidence of market power in the PL channel. The first problem with that submission is that it ignores the market definition, which is wholesale supply of DTP products in both channels. These are not separate markets. And more than that, the main existing vehicle for competition within that market as a whole is cross-channel competition. My learned friend sought to address that by suggesting, he said, that the theory of competition is that branded and PL products do not compete directly. That is simply incorrect. That is nowhere said in the final report. It is directly contradicted by analysis of closeness of competition and importance of retailers being able to flex their volumes across both channels. It's right to say that they don't compete head-to-head and directly in a tender exercise, but you've seen the significance or otherwise of that. The key competitive dynamic is that cross-channel competition and retailers flexing between the two. We then had the submission that the ability of the merged entity to wield any market power in relation to PL products would be constrained by other PL suppliers, namely Bells. And secondly, it was submitted that branded products would also be constrained by PL suppliers, namely Bells. But that simply ignores as submission the limited capacity of other PL suppliers and the fact that neither Bells nor Hengline are viewed as credible competitors by the market. More importantly, it continues the error of collapsing the merged parties' market power on this highly artificial and unlikely premise of a second contract won from Cérélia rather than from Hengline to the share only of the PL sector. It was said between 10 and 20% rather than the market as a whole. But what I'm going to show you now is that the CMA did analyse the effect of the merger on the party's incentives to degrade either its PL products or its branded products or both. When I say degrade, I obviously mean charge a higher price or reduce the quality, service, innovation, or range. And it's not as simple on the CMA's analysis as saying one is protected from degradation by the other. Can I show you final report paragraph 9.380, which is bundle page 411, internal 246. Could I ask you to read 380 and 381? 380 is taken from the mags, 381 starts applying it in the present case. And what then follows after that is three separate analyses of the various incentives which would be in play. Firstly, to degrade the just roll channel. You can see that begins lower down the same page. Then to degrade the PL channel, and then finally to degrade across both channels. Now, the weakest incentives in relation to degrading the branded, the quality product, the just roll channel, as maybe instinctively one would see. You can see the assessment at internal page 249, 9.387 is where it begins. And the first three paragraphs there consider the effect of the vertical relationship here, and the fact that Cérélia are the manufacturer of the just roll product.
Sorry, 9387.
387. Through to 389. Concluding that the incentives for the merged entity to divert sales from the more profitable branded channel to the PL channel is likely to be limited, but then for the reasons given. But on the other hand, at 390, even if that's the position, there's still some loss of constraint on just roll in the branded channel because of the merger. Pre-merger, they're unambiguously worse off if grocery retailers switch sales to the PL channel. Just roll therefore under competitive pressure to ensure its offering remained attractive relative to any competing products in the PL channel. Post-merger, the merged entity will have full knowledge of both Cérelia's PL offering and the just roll offering, will therefore have a deep insight into the quality threshold just roll products need to meet before losing sales to the PL channel. The loss of this rivalry may weaken the incentive for the merged entity to improve the just roll offering relative to the counterfactual absent the merger. So there we are, that is the incentive of degrading the quality product. But then incentives to degrade the PL channel. You see that assessment on page, internal page 251. I'll ask you to read those two paragraphs which appear on that page, 394 and 395. the point I'm going to draw to your attention, because of course Mr. Hoskins just asserts, well, other PL suppliers will constrain the PL product, is look at 394 here. Given the limitations of the alternative suppliers available in the market, their limited attractiveness to large retailers, and the presence of not immaterial switching costs, we consider it unlikely retailers would switch PL suppliers to the extent assumed by the parties. Again, I've shown you the evidential basis for that, and yesterday I showed you the evidence on switching. And then on the following page, there's some conclusions on the incentives to degrade across both channels. And I particularly draw your attention to, over the page 400, illustrating an example of how it could be profitable for the merged entity to worsen its terms across both of the channels. And of course here, my friend says, oh no, the fact that bells exist, and on this artificial hypothesis of having won a contract from Cérélia would be able to constrain them because there'd be a similar market share. The analysis is this: pre-merger, the PQRS offering of each was set separately, constrain each other, competed to make their products attractive relative to the other offering in the other channel. That is explained. Post-merger, merged entity will have control of both, be able to degrade both simultaneously through a proportionate price increase in both channels. The price increase of Just Roll will now be less costly compared to the pre-merger situations. Retailers are likely to remain largely indifferent between the channels, even at the elevated price levels. Some sales may be lost from retailers buying less DTP product across both channels, but diversion to the PL channel is likely to be limited compared to the pre-merger scenario. As a result, the price increase is likely to be profitable for the merged entity. These are not necessarily consistent with the deal rationale. We therefore consider that it would not be profitable and not supported by the available evidence. And that leads to...
So what's the basis for the... Some sales may be lost from retailers buying less DTB product across both channels, get that. But diversion to the PL channel is likely to be limited compared to the pre-merger scenario.
Well, because pre-merger, you've got Cérélia in the PL channel, so you can get diversion from the brand to that, as well as any other PL supplier, such as Bells or Hengline. Post-merger, given the unattractiveness of those options, the only remaining options, you have more limited options, as the retailers explained.
Is it as simple as this, that if Just Roll put it pre-merger, Just Roll put its price up, then the retailers might very well divert to Cérélia own brand products.
Yes, that's
whereas post-merger, if they put the price of both up at the same time, there's no incentive to try and save money by going to their own brand.
Not to Cérélia, because it's paying the same proportionate, but to other suppliers. The trouble is you have, as has been previously explained in the report, more limited options then. As I showed you, the retailers' views of what options would you have, who would you switch to, the others not applicable. Not sufficient quality for our customers, not full range, and so forth. And you've got the switching costs and the amount of time and how difficult it is to do that. All of that considered earlier. Now my learned friend produces a new point now, which says, but on the artificial hypothesis that a second contract is awarded and won to buy Bells at the expense of Cérélia, then their resulting PL market shares would be in a similar range of 10 to 20%. The short answer against all that background is, so what? You don't consider that market share as a source of market power in isolation from all the other factors. It's meaningless to say, well, they've got a similar market share without considering the rounded picture. So let me, I think for the first time, so I didn't think you heard any of this from Mr. Hoskins, try to identify what the legal basis is for this new complaint on an appeal on a point of law from the tribunal. Because he says that this late suggestion of a lower market share for PL in isolation, however unlikely, somehow disturbs all these conclusions. And that legal basis for that was not articulated beyond saying, he said, that the analysis of market share rebels was not wrong, but he said it was materially insufficient. Now that doesn't amount to a legal error unless it amounts to irrationality not to have had specific regard to that sub-market share calculation. And I also want to show you one authority on that, which I hope you have in the authorities bundle, because it was updated, I think, on Monday.
I'm happy to accept the test as rationality, if that helps you.
Well, I just want to put a little bit more
That's fine.
flesh on that bone. It may not be a controversial principle. I hope at tab 31 you have the Supreme Court's conclusion in Friends of the Earth, its judgment in Friends of the Earth.
Yes.
Oh, good. I'm relieved to hear that. And I just want to show you, this is the judgment of Lord Hodge and Lord Sales, with whom Lords Reed and Leggett and Lady Black agreed. And I just wanted to take you to paragraph 116, page 768.
Paragraph 116, yes.
And this is the most recent and most authoritative explanation of what's sometimes known as the credence principle. Going back to Fewings in paragraph 116, about three categories of material considerations: those which the statute requires regard to be had, those to which the statute requires regard must not be had, but third, those to which the decision maker may have regard if, in his judgment and discretion, he thinks it right to do so. There is, in short, a margin of appreciation within which the decision maker may decide just what considerations should play a part in his reasoning process. And then that was considered in the New Zealand Court of Appeal in credence. In the second half of that quote, it's not enough that the consideration is one that may properly be taken into account, nor even this is one which many people, including the court itself, would have taken into account if they had to make the decision. But in the rest of that paragraph, there will be some matters so obviously material to a decision on a particular project that anything short of direct consideration of them by the public authority would not be in accordance with the intention of the Act. The court explains that all that was approved as a correct statement of principle by the House of Lords in Findlay and a raft of further authority. And then at 119, as the Court of Appeal correctly held in Baroness Cumberledge, in line with these other authorities, the test whether a consideration falling within the third category is, quote, so obviously material that it must be taken into account, is the familiar Wednesbury rationality test. And at 120, it's possible to subdivide the third category of consideration into two types of case. First, the decision maker may not advert at all to a particular consideration falling within that category in such a case, unless the consideration is obviously material according to the Wednesbury irrationality test. The decision is not affected by any unlawfulness. And the second case is in paragraph 121. Decision maker may turn their mind to a particular consideration falling within the third category, but decide to give the consideration no weight. That was the present case. The question again is whether the decision maker acts rationally in doing so. This shades into a cognate principle of public law that in normal circumstances the weight to be given to a particular consideration is a matter for the decision maker, and this includes the decision maker might, subject to the test of rationality, lawfully decide to give the consideration no weight. And that's Tesco Stores, the authority for that. So those are the principles there. The question is, was this a material consideration which was so obvious that the CMA could not rationally fail to have regard to it? And it's in that context, of course, that one realises there's a double significance to the point that this point has not been raised previously by the parties at all, either before the CMA or before the tribunal. There's not only the procedural point, but also it's rather odd to be saying for the first time in the Court of Appeal that this was a point that was so obvious that any rational decision maker was bound to have regard to this factor when it hasn't been mentioned at all, despite, it may be an understatement, extensive submissions, including on market share, by the parties during the course of the 6-month-long investigation and the extent of the appeal which has happened since then. But secondly, of course, there is
a broader point for us. I mean, we've allowed Mr. Hoskins to argue it as he sees fit, but we grapple at the end of the day with how we approach the question. An issue which was not raised in front of the CMA or the CAT, and we're dealing with some relatively arcane issues of law here, but I mean, there is a serious issue for us as to how we approach this. We've understood the merits, we've seen what you said in the FR about this in the FR. We have to decide at the end of the day, a bright line. Do we permit this to have permission and then deal with it? Or do we say this is not the sort of thing we should grant permission in respect of?
Well, come to that exact point, which is what I called a moment ago the procedural point, if you like. And my clear submission is it is not appropriate for the court to deal with, even though if the court does deal with it, it can be dealt with in the manner that I've just outlined. Yeah. But the reason why it's not appropriate is a deeper question of principle. We don't actually know from the decision whether this was a point which the CMA never alighted upon and didn't mention it for that reason, or just a point which it may have considered along the way but attached zero weight to it, and so didn't put it in its reasons and didn't include it in its reasons because the point wasn't raised, or what. We don't have any primary decision on this whatsoever. I've given you a partial answer, my best answer, based on what we do have in the context where this point was not put in issue, and so it suggests it falls a long way short of some kind of irrationality point. You couldn't proceed along that line with that without focusing in on that narrow subdivision of the market rather than, as they did, take account of all the circumstances more generally. But I said it's quite wrong to allow that sort of really a merits point to be introduced at this stage and for parties not to bring forward their whole case before the CMA in the first place, and still less when it's not been brought before the CAT.
There was always material which bears upon the issue as you've shown us, but it's quite an important point of principle for us to grapple with as to we do allow new matters on occasion to be brought into an appeal, particularly if they're points of law or if they arise out of uncontroversial material and it's the inference to be drawn from it.
Yes.
We don't know what the CMA, we may know, we may be able to speculate as to how the CMA would have dealt with it. We don't know for certain.
Well, that's the submission I've made to my lord. I think my lord has it, and that is a reason in principle not to deal with it. If there's a new point of law, that's one thing. If it's uncontroversial facts, that's another. But this is the assertion that this was a critical, indeed essential, part of any rational analysis by the CMA is effectively, rationality points can shade into merits points. You can only really assess the rationality of that in the light of whatever the CMA made of it on the merits. And it's precisely because it wasn't raised, and there's no express reasoning dealing with that point for that reason, that the court finds itself in a position where it can't assess the rationality of reasons given by the CMA. All I can say to you, to the extent the court is prepared to accept it, is it's obviously not one which was so obvious that it had to be considered. And it's difficult conceptually to say why somehow just a simple market share on that limited basis somehow tips the balance.
It works both ways.
Could conceivably do so.
If it was so blindingly obvious that you should have dealt with, the CMA should have dealt with it, then why wasn't it raised by the parties? And equally, if it wasn't raised by the parties, it was incumbent upon them to do so, and the CMA can't be criticised for not dealing with it.
Absolutely.
There will also be some obvious points that the classic analysis has got to be grappled with by the CMA, but this is a nuanced. It's a different point there. Yeah. We also have the problem is if we thought that Mr. Hoskins, with his characteristic skill, persuaded us this was a blindingly good point, what we then do with it, given that it hasn't been considered either by the CAT or by the CMA? Would we set aside a decision on that basis?
Well, so I'm at the end of my submissions on bells now. You recall the way Mr. Hoskins summed up his submissions on bells, which is, you may not think any of these points are individually that strong, but you've got to have an overall view. Well, a series of weak points, I would say, of course, don't somehow congeal into a strong one. But even if there were a point, an individual point, say, such as this one, if the court were persuaded that there was an aspect of irrationality in that, that's not the end of the inquiry. You don't say, right, I found one document in all this which you've slightly misunderstood, that doesn't bear that meaning, therefore the decision is irrational. Some sort of judgment has to be made then as to whether the conclusion, the ultimate conclusion, was irrational. You do have to put the entire picture together.
Would this have made
Otherwise,
a
you-
difference
you-
on balance?
Yeah,
to-
does it
to
make a
the
difference? Is it
totality of the
material? Yeah.
decision making?
Is it a material error such that, it's been put in various ways, but there is a realistic possibility that a different outcome could be reached on remittal. I have referred under some of my subsequent submissions to the well-known tests in relation to inevitable outcomes and so forth, reasons why even if there is an error you don't remit. But even before you get to remedial questions like that, the ultimate question is the conclusion irrational? So even if on one particular document you can say, look, they've completely misunderstood this document, they've got that wrong, it does not follow as night follows day, that therefore the whole thing has to be remitted to be reconsidered. There has to be an analysis of what part that conclusion played in the context of the wider conclusions, and whether the ultimate conclusion can therefore be said to be irrational. So that's all I want to say on that, because on my case is none of this is irrational. All of the evidence was taken into account, capable of bearing weight, and the judgment that the constraint is limited in the context of the underlying nature of the competition concern is rational. Now, the tribunal's judgment at paragraph 168 is the paragraph which deals with this. I'm not going to go through that in detail. Can I refer you to my skeleton argument, paragraphs 43 to 47, which deal with the criticisms of the tribunal's treatment of this point. But I say, if I'm right, that actually the court is satisfied looking at the underlying evidence and the CMA's conclusions that they were not irrational. At this stage, before this court, permission having been granted, the question which the court is answering is really the same question as the tribunal was answering. It's in one sense neither here nor there what the tribunal made of it. But in fact, the critical conclusion which they reach is the long list of factors at play, as they put it, were sufficient to support the reasonableness of the decision. And that might be thought to echo the conclusions, which I'll show you in the report. Well, there's this long list of factors. Well, it's everything I've shown you, of course, but it's brought together at 9.335 onwards. This is page 398.
Just before you do that, I mean, I found 168 not the most helpful of paragraphs to unpick. In the first paragraph, or the first part of it, I wasn't certain whether they were levelling a criticism at the CMA or whether this was an explanation of an overall approach, that it's not for the CAT to decide what his CMA might have done in different circumstances or different evidence, or whether it came to a different view, might have come to a different view.
Yeah.
I mean, is that just a description of an overall approach, or is that a criticism of the CMA?
It's not a criticism, it's an observation premised by, given the diverse mix of factors taken into account, it's entirely possible that they could have reached a different outcome on this assessment. In other words, you could, the CAT thought, look at all that evidence and come to some other view. The evidence is capable, it seems to be indicating, of bearing more than one conclusion. We know that's not the test on JR, but they're making that observation. They then say it's possible that this might have affected its overall SLC assessment. Again, no more than that. It was open for the CMA to have done more to explore whether any given loss of Cérelia's PL volumes to a rival PL supplier would, if credible, heavy caveat there, have been sufficient to provide an effective competitive constraint on Cérelia's pricing of PL products, thereby placing less emphasis on simple market share considerations. Pausing there, as I have shown you, and I'll show you again in a moment, there wasn't actually much emphasis on simple market share considerations when you come to the conclusions. But what's being said here is you could have investigated more. Now this is it would have been open to you, but this is the Tameside point, if you like. The test, again, as to whether there's an error because a line of inquiry wasn't gone down and investigation wasn't sought in one factor or another, is again a rationality test. The question is it irrational? not to undertake further investigations. We have
What are they responding to here, given that it's common ground that the point?
They're not responding to anything. This is their own evaluation. It's their own overall evaluation, I think driven by the Economist member who was interested in this point during advocacy, but it's a tribunal decision, but it's clearly something which they were considering and thinking about. And they came to the conclusion saying it would have been open for you to do this, but it's not unreasonable, it's not irrational that you didn't do this, applying the Katoon test. So that's where they go on. However, again, note the caveat, if credible. It's evident from the long list of factors at play here that CMA is entitled to considerable discretion when making this assessment. We cannot say it was unreasonable, in other words, irrational, to draw the conclusion it did and not make further specific inquiries. And then Cérelia's argument about the existence of Bell's spare capacity is contentious in its own right. Pausing here, the contentious point is not, of course, as to the existence of spare capacity. That's acknowledged in the CMA decision. The point is that's not the whole story. It's not just reducible to a question of capacity, hence also addresses only part of the picture that was relevant to the CMA's deliberations on this point. There was sufficient information for the CMA to conclude that Bell's spare capacity was only a limited competitive constraint for the reasons set out in the decision. So again, although it's a brief paragraph, it does adopt, in my submission, fairly the reasons set out in the decision, which I've shown you are rational ones. Bell's had left its options open and naturally wants to see how its new contract would develop before taking a decision on whether to explore taking on any new large contract. That goes to the even if point, but it is beyond that, if you like, of marginal significance. And then at 169, again, I don't want to labour this point, it's in our skeleton at paragraph 47. We give a reference to a general point, yes, at 47, a general point made in the final report at paragraph 6.35, which is on internal page 58 of the report. But the relevant passage is at internal page 60. E, evidence from third parties. Again, this is a summation of the MAGs, again, of the general guidance, recognising that some third parties have an interest in the outcome of inquiry. We've given due regard to a range of factors, including the incentives of the party giving that view, the extent to which the party had knowledge that was relevant to the subject areas being explored as part of our assessments, the extent to which the view was corroborated by other evidence available to us. So they do, of course, routinely, when assessing the weight to be given to evidence, assess the incentives and the state of knowledge of those giving the evidence. The point I made earlier about Bell's, of course, not knowing what was being said by the supermarket concerned when describing its optimism as to whether or not it might have a future contract from them, but also its concerns about whether it might have a future contract from them, and having all its eggs in one basket. So, all matters such as that are routinely taken into account, but I cannot say that there's any special point in relation to Bell's beyond that in this question. It's a point that the tribunal clearly had in mind, and it's a further reason why caution should be adopted before interfering with the allocation of weight accorded by the CMA to the evidence by condemning it as irrational and beyond the reasonable response.
Is it entirely logical to say that a third-party competitor would seek to piggyback or trade off the benefits of a large merger, or is it the other way around, or is it ambiguous?
It could be in this context. It could. I mean, you could make an argument either way, and it'd be a merits point. But in this context, of course, one of the risks which the CMA were concerned about were the degrading of the PL channel, and it might be that from Bell's point of view, again, ignorant of what the retailers were saying about them, they hoped that they might pick up some more business, at least up to that capacity that they had in due course. And so that would be what the tribunal had in mind. You could equally make an argument the other way, but the material point I make is simply you do need, as a CMA always does, is to understand bear in mind incentives, bear in mind state of knowledge, and accord weight. And there's nothing in anything I've shown you which supports the appellant's assertion that the result arrived at here was an irrational one. Well, so that's Bell's. We hope to deal with Hengline more briefly. Mr. Bailey is going to take care of ground 2.
Okay. Yes, Mr.
May it please the court. I'm going to deal with ground 2 in 3 parts. First, to deal with the new argument that was at the forefront of Malone and Friends submissions yesterday as to whether we gave an adequate gist of the case on Hengline to Cérélia. We say that we did, and I'll show you the provisional findings and the consultation paper, but also importantly, how Cérélia itself understood the case against it at the time prior to this litigation. The second part will be to deal with the so-called volte-face argument. And the short answer to that is we say there wasn't any reversal of position, and I'll show you the passages in the final report to that effect. And then thirdly, I'll deal very briefly with the criticisms that are made of the tribunal judgment. So turning then to the question of the adequate gist, can I ask the court to turn up the rationale?
Can I just ask you before you do that?
Of course.
Just dealing with the procedural point. The volte-face argument was advanced in front of the CAT and not really addressed. To what extent is the volte-face argument and the consultation argument, the gist argument, variants of the same theme, in which case we shouldn't really get too worked up about the application for permission to end, or are they different, in which case we might?
So I think they are separate, but they are related. At first instance, the way it was advanced was that the volte-face was said to illustrate the irrationality of the conclusions in the final report. And in paragraph 170, the tribunal then deals with essentially the ground and says, we find that there is a rational conclusion on Hengline. The point that's now being advanced, the new point, is a procedural one, which, as Malone and Friend said yesterday, sort of actually has its own, what he says, its own merit. And it is said that we failed to consult under section 104, and therefore, if that were right, then that has independent significance, quite apart from the rationality of the conclusions reached. So that's why I propose to deal with them sort of in this order that I am. And then I would perhaps address the court at the end about the discussion you had with my learned friend about whether a permission should be granted, because I do accept that it is a different nature from the Bell's point. Which
It's an easier one for this court to assess. That doesn't mean to
is.
say
I accept that.
that you've granted permission. And we're in a better position to review this, almost like a point of law, the inference to be drawn from the document. We can see what was said in the provisional findings, see what was said in the FR, and one can draw inferences.
Yes.
But that doesn't necessarily mean to say permission is granted.
No, my lord, I agree that it doesn't necessarily follow. It was raised very late on. One does want to encourage litigants to raise matters at first instance, but I accept that it's a procedural point. It's narrowly confined. So, if I may, I'll turn then to the first part, which is the provisional findings. They're in the rationality core bundle at tab 1, at page 2. And yesterday you were shown the final paragraph, 9.199. I'd like to start at the beginning, if I may, and I'd like to make 6 points. And the first of those is relating to Hengline's market position. And I'm at paragraph 9.182 on page 2. And you can see here that the CMA provisionally is setting out Hengline's share of supply and how it has changed over time. And my lords, you'll see that it cross-refers to paragraph 34 in Appendix C. Now, we don't have that appendix to the provisional findings in the bundles, but we do have exactly the same appendix to the final report. And I hope it will be useful just to very briefly look at the changes in the shares of Cérélia and Hengline over time. So if I could ask your lordships to turn up the core bundle, tab 13 at page 554, please.
And the essence of this point, and what just so I've got the focus in my mind,
Yes.
it's not on whether they were a constraint, it's whether it was limited.
Indeed.
The word a is consistent throughout both the provisional findings and the final report.
That's right.
It's
But
the word limited which comes in. So
yes.
the question for us is whether when you look at the provisional findings, they were accepted as a constraint, but in the round it was still limited, and whether that shifted.
That's right. So we say that in the provisional findings, the additional evidence consultation paper in December and the final report, you'll see a consistent theme that we recognise that it is a material constraint for some retailers, but it's actually an insignificant constraint for other retailers. And that's why there's a sort of mix of evidence, and then a judgment has to be made. And I want to show you sort of how that develops, and this is just one part of that broader picture.
And I'm sorry, just to keep pressing you, and so the relevance of identification of gist is so that the relevant parties know what their target is.
Yes, and I'm going to show you that Cérélia understood that it was a limited constraint that was being exerted. I'll show you a couple of passages in its own response to the additional evidence paper that make that clear.
Yeah.
So we're in core bundle tab 13, page 554, and what you can see from this figure is just the trends over time in the shares. And you can see quite vividly what has happened to Hengline over time, in particular around 2016 and the Brexit referendum. And you can see the gap also between the blue line and the green line. And so we say that that is an important point to bear in mind. We accept, of course, that you don't need to go too far back in time, and we want to assess the merger based on the position when the merger was completed. But it's important to sort of have this context because we are looking at the relative competitiveness of Hengline as a supplier. So that is the first point to bear in mind, and we'll see how that's then confirmed in the final report.
Just as a matter of interest, Mr. Bailey, why are the lines for Cérélia and Hengline in the last 2 years dotted?
Gaps in the data, my lord.
Sorry?
The data wasn't entirely complete.
The data wasn't
Yes.
complete, so it's, yeah, okay.
So that's the reason why
That's
it's...
what you say, yeah, thank you.
If I can ask your lordships to go back, please, to the rationality core bundle and the provisional findings. So tab 1 and page 2. So I said there were 6 points I wanted to pick up. This is the second, and it's at paragraph 9.185 at the bottom of page 2. Now this is a point that had been pressed by Cérélia pretty much throughout, including before the tribunal, and it relates to Hengline's capacity. And you can see the relevant figures there, and you can see also the statement made by Hengline. And all I want to do at this point is just to note that the CMA took this into account as a relevant consideration. It was to be weighed against the other factors, but as we will see, capacity is not the reason why the CMA provisionally found Hengline was a limited constraint. The third point is to be found on page 3, and it's paragraph 9.187. And we move now to Hengline and its views, its product range. And we can see in 9.187 that it told the CMA it does produce very similar products to those produced by the parties, albeit in the second sentence, it doesn't produce frozen products, unlike Cérélia, and it doesn't produce the rather fascinating canned products, unlike Just Roll. So it does have a narrower product range, and that is a point that was picked up by one very well-known retailer. If I can ask your lordships just to turn over the page to 9.192, the final sentence, you'll see that well-known retailer saying Hengline offers almost the entire range, but there are key products missing. And it was referring in particular to not offering dough in block form there. If I could ask the Lordship just go back to what Hengline was saying, 9187 on page 3. In the last sentence, you'll see the philosophy that was adopted by this German supplier, and it's to use natural ingredients, so that's the ethanol point that my Lord Justice Green was discussing with my learned friend, and you can see that it wants basically to produce in that way, and that is also a point of some significance, because as my learned friend Mr. Palmer said this morning, certain retailers have very strong views about not using products that include alcohol as a preservative. And we can see that point if I can ask you to turn over the page again. Page 4, paragraph 9.192. A leading supermarket says in terms, the second sentence, it would not use Hengline as a supplier because it uses alcohol and is unwilling to change this. And we saw earlier this morning the strong position in the market of that particular retailer. Can I, at this point, show the court very briefly a couple of the underlying documents that support what is being said there, just so that you can see the context. The first of which is in the same rationality core bundle at tab 11, at page 32. And you can see at paragraph 7, before the retailer is explaining, before switching to Cérélia, this retailer had worked with Goldenacre, that's the UK partner of Hengline, but stopped using them, and then two particular reasons are given. The first, Brexit-related concerns, friction at the border. That's an acute concern for Tesco, given, excuse my language, for the retailer. Lovely. Moving on, the second point is the point we've seen already. That's the concern about quality and the natural ingredients. But there is a third point that's actually of some importance in paragraph 8. The retailer says it has been talking, so it knows the UK partner of Hengline, but says the solution is far from ideal, not only to the concerns highlighted above, but also cost concerns. And it goes on to explain here, retailer margins are very thin, and as the category is very price sensitive, this is not the preferred route. So in terms of whether Hengline is a competitive constraint, we can see quite clearly from this that it is not considered to be so. And if I could very briefly ask your lordships to turn to tab 30. And we did see this response earlier, but in the context of bells. And at page 154, this is a slightly later document in the phase 2 process. And it's really just to pick up 2 points. Page 154, in answer to the question 17 about the impact of the merger, you'll see that 3 lines down, the retailer states in no uncertain terms, there's no other alternative supplier in the UK and in Europe that could serve this part of the own label business. Yeah. And then again, the point about alcohol. So it's very clear what it thinks about this aspect. The fourth point, if I can ask your lordships to go back to tab 1, concerns retailers' views. This is set out in several paragraphs on page 4, paragraphs 9.190 to 9.192. And the headline point acknowledged by the CMA in 9.191 is that customer views were mixed. Hengline has some cheerleaders, and you can see those set out in 9.190. On the other hand, there are some detractors, retailers, large, well-known retailers that express concerns about Hengline. Now, we've seen one of those already, but 9.192 refers to another well-known customer, and you can see halfway down, it says Hengline could potentially serve the full product range. It's unclear if it could meet its technical requirements. And just to show your lordships again an underlying document and also what is meant by technical requirements, I could ask you to turn to tab 12 in this bundle, and in particular page 37. So here we have this retailer under the heading Competitive Landscape and Ease of Switching. So it knows about the UK partner, hasn't explored the relationship with that supplier in any detail. Paragraph 14 explains why, and that's where the technical requirements are set out about auditing, labour, ability to deliver the product, which obviously is crucial. But could I also invite your lordships to note paragraph 16, because here we see the retailer set out that it hadn't explored suppliers outside the UK. It has a preference to source British where possible, and that's part of that retailer's sustainability agenda, alongside with transport costs being relevant. So that all goes in to whether or not Hengline, as a non-UK supplier, is a material competitive constraint. And we actually see, having picked up that point from the retailer, we go back to the provisional findings on the retailer views, we can see this being set out, in particular, at paragraph 9.194 on page 5, and you'll see the point we just looked at subparagraph B. And this is where various third parties told the CMA that if you're based in, presumably continental Europe, you're at a material competitive disadvantage. And it's not just the retailer we just looked at, it's also, as you can see from paragraph C, a competitor, quite a relevant one for present purposes, talking about the trend for made in Britain products, which makes it more difficult for those outside the UK. So all of this is relevant material, and it suggests limitations on the competitive constraint. The fifth and sixth points can be dealt with very briefly. The fifth point requires us just to go back to page 4, paragraph 9.193, and simply to note none of the competitors who responded to the CMA's phase 2 questionnaire identified Hengline as a competing dough-to-bake supplier that they competed with. So we're now seeing other market participants don't regard it as a competitor. Not decisive, but relevant to whether it's a constraint. And then finally, back on page 5, paragraph 9.195, the CMA, as it does throughout the provisional findings, looking at internal documents, acknowledging, yes, some of the documents do mention Hengline as being a possible threat, but it's mixed and it's a small proportion of documents. You can see the number there. That number is a fraction of the thousands of documents that were provided, which is a point noted in footnote 136 to the final report. So that's the evidence base. If I can then take your lordships to the provisional assessment, and you were shown yesterday 9.199, but it is important to acknowledge what the CMA was gisting, and it starts at 9197 on page 6, and we've seen that point. It's about the change in fortunes of Hengline on the market. That's the first point. The second point, 9.198, is the range of retailers' views. A minority thought it was a strong alternative, but some large retailers didn't consider it to be a credible alternative for the various reasons that we have seen. And then we get to 9199. And Malone Frame understandably placed great weight on the first line. The overall, we consider Hengline to represent a material constraint on the parties. But of course, my lord, the Chancellor pointed out yesterday one has to read on that that is particularly in relation to the contracts of the kind Hengline had at the time. Moreover, the first sentence is qualified by the second, where the CMA sets out its belief that Hengline's constraint is likely to be weaker in relation to the large retailers. And as my Lord Justice Green pointed out yesterday, it's the large retailers that account for a large proportion of the market, as we saw in Table 5.1. The gist continues because in the final sentence, we can see the constraint here is confined to the private label channel. There's a minimal impact on brand. Now, my learned friend in my submission rightly acknowledged that these documents need to be read as a whole, day 1, page 23. And so one shouldn't seize snippets in isolation. And he fairly went to paragraph 9 to 20, which, if I can invite your lordships, is over page 7.1. And just to pick up a couple of further points about this, you can see here the CMA is drawing the threads together to set out its provisional conclusion. And it's quite important to see what is said in the opening sentence of that paragraph, because we see it talks about PL suppliers, so that includes Hengline, individually and in aggregate, and then these words, exert only a limited competitive constraint on Cérélia. So it goes to the point that my Lord Justice Green was putting to me, that it wasn't just a constraint, we were actually saying to them that it's a limited constraint. And we can see, perhaps in slightly clearer terms, if I may say so, on page 7.2, subparagraph B, the CMA explain this, where it talks about suppliers based in the EEA. They offer some competitive constraint, and then the next sentence, the competition that Hengline is likely to offer in relation to current retail customers is material. So accept that. We saw who those customers were, but it'd be less likely to constrain the parties when it comes to contracts for large retailers. There's no need to turn it up, but the CMA, perhaps for good measure and completeness, repeats the same points again at paragraph 9261 of the provisional findings, which is on page 7.3. So that is the gist set out of the case. It's not a stark finding of, yes, Hengline's a material constraint. It's more nuanced. It acknowledges the evidence. It's evidence-based. But as my learned friend, Mr. Palmer, explained this morning, the fact-gathering process continued after the provisional findings, and it's important for the court to see what additional evidence was gathered and how Cérélia responded to it. And you, my Lord, you'll find this, and we saw it briefly this morning, and I'll just take you to a couple of passages, at tab 52. This is the additional consultation in December.
Yeah.
And you'll see on page 255, paragraph 4c, the CMA received written evidence from a particular supplier we're concerned with. And then over page 256, you can see paragraph 5, the CMA notes this additional evidence is generally in line with the third-party evidence in the PFs, provides further support for the CMA's provisional views. But of course, in paragraph 8, the CMA is inviting the parties, out of fairness, out of making sure that they have an opportunity to be aware of the corpus of material being put to them, to make representations, which Cérélia did. If I can show the court the relevant evidence, we were taken yesterday to paragraph 21 on Hengline, but it's actually paragraph 19 on page 258.4 that sets out the propositions put forward by Hengline. There are 4 paragraphs there. The first 2 deal with the familiar question of capacity. So it is accepted that this supplier considered that it could supply a large retailer. Of course, it takes 2 to tango, and one needs to identify a retailer that wants to deal with them. The third paragraph deals with the philosophy. We've seen that already. It's to do with natural ingredients, and again, depends on the retailer's preference. But could I ask the court to look at paragraph 4 in particular and read that paragraph, please?
Yeah. It's essentially the effect of Brexit, isn't it?
It is indeed, my lord. It's the frictions, costs, difficulties, together with questions of transport and petrol costs. It's all about limitations for a supplier outside this country to compete for the business of UK retailers. And that is the evidential basis upon which we then looked yesterday at paragraph 21. And the CMA saying, look, this doesn't actually move the dial in terms of our provisional findings. Nothing earth-shatteringly new here.
Although they sell in the UK under the name Golden Acre.
That's right. That's the
manufacturer in the UK.
No, they're not. It's manufactured in Germany. That's right. I think there's one customer with whom Hengline has a direct relationship, but otherwise it's all done through the UK partner, Golden Acre. Now, what you were not shown yesterday, but I hope will be helpful to see, is how Cérélia, prior to this litigation, understood the CMA's case as it was being put. And that's at the next tab. And there are just a couple of passages to pick up here, but they are quite instructive. So it's tab 53, page 260, paragraph 1.12. And you can see Cérélia is in no doubt about the case being put and is vehemently pushing back, as is its right. And in paragraph 1.12, we see as to, I'm going to say it's Hengline because we know it would, the PS concluded it was not a significant constraint for large retailer contracts who considered the lack of UK presence problematic. Now, that is in my submission, correct interpretation of what the provisional findings said. But actually, it jars with the way it's put now before this court, as if the PS had provisionally concluded that Hengline was a material constraint. In my submission, the correct position, and correctly understood at the time, is what Cérélia understood as set out in paragraph 1.12. Now, that's not a slip of the pen, because we can see, if we turn on page 264.3, this is now under the heading, Cérélia arguing supplementary paper confirms Hengline's a major competitive constraint. Paragraph 3.8 at the bottom. And we can see here, if I can just ask the court to read paragraph 3.8, please. And so what the parties do here is they argue the case on the merits, but they're in no doubt that what was being provisionally found was that Hengline's not a credible alternative. It's not a material constraint in relation to large retailers, which is the bulk of the market. As my Lord Justice Green said yesterday, an adequate gist is one that enables the person affected to understand the case against them. Cérélia understood that. It's then making various points about Hengline, its capacity, the use of ethanol, retailer preference for UK suppliers. But in my submission, that really is the end of any allegation of unfairness through a failure to consult. The gist was provided. It was provided both in the provisional findings, but also in the additional consultation paper. I was going to move on then to my second point, which is the volte face. And that is crisply set out in paragraph 44 of the appellant skeleton argument, which is at core bundle 3, page 27. And of course, you've heard my submission already. The provisional findings didn't actually find that there was a material constraint purely on the parties. But what I'd now like to show the court is what the CMA concluded in the final report.
Yep.
And I'll take this as briskly as I can. It's in the core bundle, tab 10, at page 366 of the core bundle numbering, page 201 of the internal numbering. And the court was shown yesterday 226 to 230. So what I just propose to do is simply to walk you through the evidence base, and as I do, simply give you the reference to where exactly the same point was made in the provisional findings, that these two are absolutely in lockstep with one another. It begins again with share of supply, that's 227, 228.
Yeah.
And we saw that in 9182 to 183 of the provisional findings.
Is this the same evidential base in effect as the consultation?
Indeed, my lord. I mean, actually, that could cut through it.
I mean, in a sense, if there's a volt fast, then there's some gist to communicate.
Indeed.
If there isn't a volt fast, then there's no gist to communicate because it's the same or a
It's the
variation.
same.
It is the same. So I can therefore move, the evidence base hasn't shifted.
9.227
But if there are
is
additional
the same
evidence-
as 9.182. 9.228 is the same as 9.183.
Indeed, 9230 is the same as 9.185, and one can do that forensic exercise. Of course, there are one or two new points that emerge because if one looks at 9231, that's where the CMA summarises Cérelia's position. There are points that Cérélia make for the first time, for example, on page 367.
Well, the provisional findings in consultation.
Indeed, so that is just setting out, and then of course we see the CMA responds to those submissions by Cérélia in 9245. But as my Lord Justice Green has said, essentially the evidence base is the same, and so actually what one finds is that there is no volte-face, and one can see that if I move to the assessment of the evidence, which is at page 371 of the core bundle 206 of the internal numbering. And again, some familiar themes here. In 9242, the change in market share. 9243 are the retailers' views. And again, we acknowledge it's mixed. Of course, the current customers consider it a strong alternative, but there are some very notable leading grocery retailers that don't. If I could invite the court to read paragraph 9.244, it's a very long and detailed document, but that in my submission crisply sets out the concern.
245.
9.244 and 9245 responds to what Cérélia have been saying, but it's 9244 I think captures the nub of the CMA's concern about the extent of the competitive constraint from Hengline. And so my submission on the volte-face is that it actually didn't arise, it's not a problem. Moreover, you've seen now, I hope, that there is evidence of probative value that is underpinning the CMA's assessment. And you see that it pulls the threads together in 9246 on page 208. And it is pointing out that yes, Hengline has had some recent success, but on the other hand, there are some major players in the retail market that are either unwilling to deal with Hengline for legitimate reasons. And as I did with the provisional findings, it would be right for me also just to draw to the court's attention the sort of the overall conclusion that is set out at 9310, internal numbering 225, page 390. And here the CMA is reaching its overall conclusions. We see 9310 paragraph B, suppliers based in EA, specifically Hengline, offer some constraints. And again, this is now just very familiar wording. Hengline's material constraint in relation to current customers, but more limited in respect of large retailers, and we know the reasons why. And then you can see that the CMA says in 9313, we conclude that parties face limited competitive constraints from these alternative suppliers, both individually and in aggregate.
Yeah.
I see the time, my lord.
Yeah.
I only have one further point to make, but if it's easier for me to do that at 2 o'clock for sort of...
Well, you just carry on and finish the point then.
Okay, so the third point is simply just the tribunal's judgment.
Yeah.
So you've seen how we have set out what we did during the investigation and what we concluded. The relevant paragraph is 170. That's core bundle tab 7, page 110, internal numbering page 67. And if we just look at 170, it begins by saying we don't find the CMA's conclusion was unreasonable. We say that's an unimpeachable finding. He then goes on to say, and this is not challenged on this appeal, the decision shows that Hengline became less active supplier since Brexit, and we've seen various references to that, so that is not contentious. We then see that the tribunal deals with the issue of capacity, which was a point that was pressed by Cérélia at the oral hearing in front of the CAT. And the tribunal makes 2 points here. Now, these are criticised in the appellant skeleton as being speculative and the CAT going off on one. If I may, actually what the tribunal is doing is it's saying it's all well and good to have large capacity. The first point it makes halfway down is, well, one needs to know how much of that capacity will be devoted to UK customers. And we've seen, we don't need to turn it up, but we've seen that Hengline itself acknowledged headwinds as a non-UK supplier trying to compete in the UK. That's paragraph 9.232 on page 368 of the core bundle. And Hengline also, 9.239C on page 369, acknowledging the trend to buy British, made in Britain. And so those are points about whether it would choose to devote to supply UK customers. And then, as my Lord Justice Flo had picked up, in relation to the other point here, logistical complications, that really is referring to the issue of Brexit. And again, that's points that are dealt with in the final report. Yeah. So it may not be a model of clarity, and I accept, I think my Lord Justice Green pointed out yesterday, even if you squint, you can't really see the Volt-Fast point being dealt with here. It's acknowledged in 165 of the judgment. The CMA's position is set out clearly in 167. That's consistent with what I have just said to you this afternoon. Perhaps the reason why the tribunal doesn't explicitly deal with Volt-Fast is that it is merely an argument along the way towards the overarching rationality challenge, which is set out in 160 of the judgment. And they said, well, look, we don't think the conclusion is irrational, and therefore there's nothing in the Volt-Fast argument, as I sought to show you. So every little helps, as one supermarket says. If there's anything else I can...
But don't name them.
Those are the submissions.
Thank you very much, Mr. Spector. Right, so let's say 2:05, and we'll go on to ground 3 and Greek 3, form 5. So 2:05.
Rise.